Honorable Chief Justice, Honorable Associate Justices, may I proceed? After 13 long years of extensive, comprehensive, and heated debates inside and outside of the Congress, the Reproductive Health Law, or RA 10354, has been enacted with absolute fealty to the Constitution and the Commonweal. It took almost 1.5 decades for the Congress to pass the RH bill because all of the objections and reservations of the oppositors were answered and addressed. The concerns of the allies of the Catholic hierarchy in the Congress were heard and some even accommodated. Constitutional issues were freely ventilated and exhaustively debated. The critics in the Congress participated in the long drawn-out process and even introduced amendments, many of which were accepted and incorporated in the bill. At the end of the day, the duly elected people's representatives in the political departments, the legislative and executive, have categorically spoken for the RH law. The sovereign people, majority of whom are Catholics, in survey after survey, have decidedly spoken for the enactment of the RH law, including its salient features. The international community has likewise clearly spoken in jubilant celebration of the final passage of the RH law. We earnestly beseech the Honorable Supreme Court to rule for and speak on the constitutionality of the RH law. We seek a pluralistic unanimity on a truly outstanding legislation which seeks to protect the lives and well-being of families, women, and infants by affording voluntary beneficiaries universal access to reproductive health and family planning information, services, and supplies. Educate adolescents on proper sexual values. Alleviate poverty by meaningfully addressing the empirically validated nexus between population and poverty, and accelerate the achievement of sustainable human development for the Filipino people. The right to life provision, which mandates that the state shall equally protect the life of the mother and the life of the unborn from conception, is intended solely to prohibit the Congress and the Supreme Court from legalizing abortion. Verily, what was sought to be outlawed was abortion, not contraception or contraceptives, which were vastly and readily available in 1986, contemporaneous with the deliberations and adoption of the subject provision. Indeed, contraceptives have not been declared illegal. The use of contraceptives has not been criminalized. This is a recognition that conception is not abortion. This is a recognition that contraception is not abortion. While contraception prevents pregnancy, abortion terminates pregnancy. To ban contraceptives now is a veritable retrogression. The expert opinion of the UNDP, UNFPA, and the WHO underscores that, and I quote, "It is universally recognized that contraception is the most effective intervention to prevent unintended pregnancy, abortion, child and maternal mortality and morbidity," unquote. Specifically, it has been validated that regular and correct use of contraceptives reduces abortion rates by as much as 85%. The following provisions in the RH law make the Act's anti-abortion policy indisputable. First, it recognizes that abortion is illegal and punishable by law. Second, abortion is not included in the menu of family planning methods, which is limited to those which are medically safe, non-abortifacient, effective, and legal. Third, one of the elements of RH is the prescription of abortion. Fourth, RH rights do not include abortion and access to abortifacients. Fifth, the repealing clause provides that prevailing laws against abortion are not repealed modified, or amended. Finally, Section 4A defines abortifacients as referring to any drug or device that induces abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination of the FDA, a formulation introduced principally by the oppositors of the RH bill. Consequently, the following are unmistakable. 1. An embryo or fetus must pulsate in the mother's womb in order that an abortion can be committed to the use of abortifacient. This adheres to the standard definition of abortion, which is the expulsion of an embryo or fetus before it is viable. 2. The prevention of the fertilized ovum from reaching and being implanted in the mother's womb makes a drug or device an abortifacient as determined by the FDA. This addresses the claim, albeit not medically and empirically validated, on the third mechanism of action of contraceptives, which purportedly makes the uterine wall hostile to the fertilized ovum's implantation. 3. The Act's prescription of the third mechanism of action is intended to assure the implantation of the fertilized ovum in the mother's womb for its viability. This makes the RH law genuinely protective of the life of the unborn. This innovative definition expands the limited action of abortifacients from the traditional destruction or expulsion of the fetus to encompass preventing the fertilized ovum from implanting, a prior phase in the reproductive process. This formulation was accepted as a concession to the critics of the RH bill, who wanted to ban the yet unproven third mechanism of action of contraceptives. Consequently, the Act protects the implantation of the fertilized ovum while in transit to the uterus, even before it becomes a fetus. Verily, the petitioners have no reason to complain. 4. The first two validated mechanism of action of contraceptives, which are the inhibition of ovulation and the prevention of the sperm from fertilizing the egg, are obviously not included in the definition of abortifacients because prior to fertilization, there is no unborn which is entitled to protection. Hence, the avoidance of fertilization is not abortion, and contraceptives with these pre-fertilization actions are not abortifacients. The foregoing unequivocal provisions uphold the constitutional ban on abortion and the mandate to protect the life of the unborn. With the inordinate concentration on protecting the life of the unborn, almost forgotten is the first part of the mandate, which calls for the equal protection of the life of the mother. The RH law is not oblivious to this twin mandate. The promotion of RH and family planning equally protects the life of the unborn and the life of the mother, the living person in the equation. Planning a woman's pregnancy is protecting and saving her life from avoidable maternal morbidity and mortality. The use of contraceptives minimizes the incidence of high-risk pregnancies, which result to maternal death. High-risk pregnancies are associated with the phrase, too young, too old, too many, and too soon. Pregnancies among teenagers and older women, as well as those of women who already have many children and those who have unremitting pregnancies, make such women prime candidates for maternal death. The NSO recently reported that mortality in teenage pregnancies has increased, even as 14 Filipino mothers die daily due to complications related to pregnancy and childbirth. This is due to lack of access to RH services and products. Multiparity or having many children is gravely associated with maternal mortality because with each additional pregnancy, a woman's life time risk of dying from pregnancy or childbirth-related causes progressively increases. Family planning saves lives. This is the simple and incontestable truth. The WHO, the UNDP, and the UNFPA confirm that correct and consistent use of contraceptives will prevent 1/3 of all maternal deaths. Moreover, birth spacing through proper contraception assures the birth of healthier infants. The WHO concludes that if a woman have information and access to contraceptives and are taught If women have information and access to contraceptives and are taught to use them properly, the fall in maternal mortality is likely to be even greater than the fall in the pregnancy rate. Since contraceptives saves lives of women and infants, far from being poison, they are medicines that avert maternal and infant morbidity and mortality. Maternal deaths and infant mortality have become silent epidemics of alarming proportions. Although pregnancy is not a disease, it can kill. It is fraught with mortal risk. Thus, contraceptives are included in the WHO's model list of essential medicines. Similarly, the FDA registers and approves contraceptives for sale and use as drugs and medicines. While contraceptives have side effects, they are not singularly life-threatening. Even aspirin has side effects. The actual benefits of contraceptives far outweigh their potential risk. The chances of dying within a year of riding a car is 1 in 5,900. It is 1 in 200 from using pills, 1 in 1 million in having a vasectomy, 1 in 10 million from using IUD, and absolutely 0 for condom use. But the risk of dying from a pregnancy is 1 in 10,000. All methods of contraception, whether natural and traditional or artificial and modern, have one common objective: the prevention of unplanned pregnancy. The differences lie in their differing efficacy and their contrasting harmony with human instincts and desires. Father Ruben Canseco, SJ, wrote that, and I quote, "Natural family planning has not worked effectively in our country. For so many poor, uneducated couples, learning NFP as the only means of family planning is too difficult, cumbersome, and needs much discipline and spirituality. Many are not able to make it. The poor are already deprived of so many things, and to deprive them of love-making when they spontaneously feel like doing so is to make their lives even more miserable," according to a Jesuit clergy. The Proclamation of Tehran on Human Rights in 1968, of which the Philippines is a signatory, declares, and I quote, "The protection of the family and of the child remains a concern of the international community. Parents have a basic right to determine freely and responsibly the number and spacing of their children," unquote. Millennium Development Goal number 5, as amended, aims at achieving universal access to reproductive health by 2015. Again, the Philippines has committed to achieve the Millennium Development Goals. Freedom of informed choice is central to the reproductive health bill. While the state is mandated to provide universal access to legitimate contraception, the ultimate choice belongs to women and couples, the voluntary beneficiaries. A couple or a woman may opt not to choose any method at all. This option is both a civil and religious right, which the RH law respects, and protects. Neither the church nor the state can compel citizens or the faithful to adopt a particular family planning method. The free and responsible choice belongs to the acceptor. The UNICEF asserts that, and I quote, family planning can bring more benefits to more people at less cost than any other single technology now available to the human race. This would be true even if there were no such thing as a population problem, if one just considers the prevention of maternal and infant deaths from unwanted conceptions. Pertinently, the 2012 State of the World Population Report declares that having children by choice and not by chance leads to healthier families and communities. Considering that the RH law is against abortion, abhors coercion, and respects freedom of informed choice, this act is not only presumed constitutional, it is indubitably constitutional. Thank you, Your Honors. Your Honors,
Yes.
I have an impaired knees, and pending my operation, I cannot stand for long periods.
It's all right. Congressman Lagman, you may take the seat, please. But the justices might have questions for you.